Good morning, everybody. Are we ready?
Yes, we are, Chair. Ms. Tabashi will lead Mr. Matibula.
Okay, thank you. Mr. Matibula needs to take the oath or do the affirmation.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath in the prescribed form to be binding on your conscience?
Yes.
Please raise your right hand. Do you swear that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you.
Thank you. Mr. Bashe.
Good morning, Chairman. Just
Good morning.
For the record, my name is Leah Tabashe, and I'm a member of the team of evidence leaders attached to the Commission. I will be leading this witness, who is Mr. Ndleleni Willie Matebula. He is the acting Chief Procurement Officer at National Treasury. Chairman, with your leave, I just have a fairly brief opening statement before I actually lead this witness.
Before you do that, I don't know what it is, but I'm not hearing you as clearly as I should. I don't know whether raising your voice will cure that or what will happen.
Shall we try this? There's an echo when I bring the mic closer, Chairman.
That was better.
Was it actually better? I'll also try and speak up.
Yeah, okay, no, that's fine. But can everybody hear me well?
Yes.
Okay, all right, thank you. Let's try.
Thank you, Chairman. Mr. Matebula has been at National Treasury for about 17 years. He will be assisting this commission as provided for in Rule 6.1, read with Rule 7.1, Chairman, by taking the Commission through the prevailing public procurement regime in South Africa. These two rules provide respectively that this Commission may receive any evidence that is, one, relevant to its mandate, which evidence, two, should be significant in advancing the work of the Commission. As will become apparent, the evidence to be tendered by this witness falls squarely within these parameters. It is contextual evidence that is intended to be one of the foundational building blocks that will assist the Commission understand, just by way of example, the institutional arrangements that impact the regulation of procurement in the different spheres of government. That's just by way of example, Chairman. The evidence of Mr. Matebula falls outside the parameters of Rule 3.3. He does not implicate any persons in his statement. His testimony does not address the factual circumstances of any alleged malfeasance that may have taken place in the past. His evidence is technical and really intended to give context, nothing more. In the circumstances, there is no basis, in the view of the legal team, for any party to seek your leave, Chairman, to cross-examine Mr. Matebula. Chairman, I beg leave to hand up a hard copy of his statement for your ease of reference. It will form part of the bundle of statements that will be handed up to you during the course of the Commission's work. And in that respect, I have marked it Exhibit B1.
Thank you.
Just to give a quick overview, Chairman, of the tasks of the Commission, this Commission has been tasked with inquiring into, with making findings, reporting on, and making recommendations to the President of the Republic of South Africa on the matters tabulated in terms of reference 1.1 to 1.9, guided by, among others, relevant legislation, policies, and guidelines pertinent to the matters under scrutiny. This is precisely where the evidence that Mr. Mathebula will be tendering will be positioned, with specific reference, of course, to the legal framework that bounds public procurement. Mr. Mathebula's evidence could also be of value in relation to informing the submissions that the team of evidence leaders may wish to make in relation to the possible recommendations that the chairman may want to make to the president. In due course, Chairman, evidence on the procurement of goods and services by organs of state will take up much of this commission's time. This is inevitable because one of the central allegations made in, amongst others, the State of Capture report of the Public Protector, as reflected in terms of reference 1.4, 1.5, and 1.6, is that of the unlawful award of tenders and contracts by SOEs and public entities to private individuals, companies, business entities, and organizations. It is evident, therefore, that the testimony of Mr. Mathebula, which traverses this terrain from the perspective of what Section 217 of the Constitution sought to provide for, will clarify what the operational rules of engagement are that give effect to Section 217, I beg your pardon, of the Constitution. This testimony will also, I hope, throw light on whether the prevailing legal framework was or is open to manipulation by public functionaries, and if so, in what respects. In essence, Chairman, the testimony of Mr. Mathebula on the legal framework of public procurement is to assist this commission in discharging its mandate of establishing whether the allegations of state capture that have been made have merit, and if so, in determining what part of public procurement played a defining role in the form state capture may or may not have taken in this country. In closing, Chairman, might I indicate that as the Commission's work gains traction, National Treasury will in all probability be in attendance again to address any other matters that are of significance to the mandate of this Commission. Today, however, the focus of Mr. Mathebula will be very narrow. It is just to give context to the Commission on the procurement landscape, primarily with regard to public procurement, as well as state-owned entities, and not, as reported in one Sunday newspaper, to speak to the investigation reports that National Treasury has commissioned in the recent past. That's not the mandate for today, Chairman. Subject to any directives from you, Chairman, any matters concerning National Treasury that require further interrogation will emanate from the factual evidence that will be placed before this Commission in due course. As and when necessary, National Treasury officials can then be called to clarify relevant aspects pertaining to that factual evidence. It is possible, therefore, Chairman, that this will not be Mr. Mathebula's first and last appearance at this Commission. In like vein, it is hoped that the information that Mr. Mathebula will be imparting today is not the only evidence that National Treasury will be assisting this Commission with. Chairman, might I proceed to lead Mr. Mathebula?
Just so that one understands the significance of the evidence that Mr. Mathebula will give, is it correct to say it seeks to give the foundation on which any allegation that either state capture or corruption or fraud that falls within this commission's terms of reference entailed a departure from procurement processes. In other words, this evidence will say this is what should happen in relation to procurement, and if anything that happened in relation to state capture, corruption or fraud in relation to procurement within South Africa government, then it should have followed these processes. And if it departed, it means it was not in accordance with these processes.
Absolutely, Chairman. It's a yardstick. It
Yeah.
gives a framework
Yeah.
within which the evidence that will be led
Yeah.
by this commission can be compared to or tested against.
Yeah. Thank you.
Thank you,
You
Chairman.
may proceed.
Thank you, Chairman. Mr. Matebula, is it correct that you are here to assist the Commission by explaining the public procurement framework that flows from the provisions of the Constitution?
Maybe before he responds, let me just confirm that he is happy to give his evidence in English.
Thank you, Chairperson. Yes, I am happy to do so.
Thank you very much.
Thank you. Thank you, Chairman.
Okay.
You were going to respond to that question? That you are here to assist the Commission?
That is true, Advocate.
Thank you. And that the statement...
I'm sorry again. You will also have to try and raise your voice, Mr. Matebula.
Okay.
So that we can hear. I don't know whether I'm the only one that has a problem. Maybe if I am the only one, then maybe there is something wrong with my ears. I hope that people right at the back can hear you well as well. So let's try and make sure we raise our voices sufficiently for everybody to hear. Thank you.
Thank you. And Mr. Matebula, if you would please address the Chairman. I know I'm asking the questions, but the responses go to the Chairman.
Okay.
Thank you. The statement that I have handed up as Exhibit B1, which is dated the 15th of August and signed in Pretoria, is that your statement?
Thank you. Through you, Chair, yes, it is indeed my statement.
And is it a statement you wish to rely on in these proceedings?
It is correct, Chairperson, that is a statement that I will be relying on during the proceedings of today.
Please take the Commission through the salient points of your statement, starting with an introduction of yourself and your term of service within National Treasury.
Thank you, Chairperson. As indicated, of course, in my statement, my name is Willie Matebula, and of course, Ndleleni is my African name. And I am currently the Acting Chief Procurement Officer at the National Treasury of the Republic of South Africa. This is a position that I have occupied since September 2017. Now, the Office of the Chief Procurement Officer is responsible for regulating procurement and modernizing the supply chain management system across all spheres of government. This office also plays an oversight role on procurement so as to improve efficiency and effectiveness in the system. Included in the mandate of the OCPO is the responsibility of promoting, supporting, and enforcing transparent and effective management of the supply chain management system. Now, since 2002, and prior to the establishment of the Office of the Chief Procurement Officer, I was employed as the Chief Director, Contract Management, under the Specialist Functions Division within the National Treasury. In this position, I was responsible for facilitating the arrangement of transversal term contracts on behalf of government. These are contracts that are cross-cutting. If I may, through you, Chair, just explain a little bit what transversal contracts are. These contracts, of course, are contracts that are common across the whole of government. I may just make an example. If you take fuel, fuel is consumed by everybody in government, from Cape Town to Messina and vice versa. Now, this particular contract is transversal, and it actually doesn't make sense to allow every government department and government institutions to have their own individual contracts for the supply and delivery of fuel in the country. But what we do, we then consolidate all volumes and facilitate one contract centrally, of course, to derive benefits out of economies of scale, and also to apply government policy consistently. They are strategic in nature, and they also cross-cutting. That's what transversal contracts are all about, in a nutshell. There are many of these contracts, of course, in government. Now, in 2015, I assumed the position of Chief Director, SCM Policy and Legal within the Office of the Chief Procurement Officer at the National Treasury. In this position, I was responsible for the SCM policy development, including the setting of norms and standards for implementation thereof. In other words, setting the rules of the game, how the game should be played and within what rules. That's the position that I held prior to being appointed as an acting Chief Procurement Officer.
So, Mr. Mathebula, you therefore are saying to us that you have an intimate understanding of supply chain management processes, procedures, and prescripts.
Through you, Chair, thank you very much. Yes, I am. I understand the policies of government insofar as supply chain management is concerned. And of course, I discharge this responsibility with oversight over all spheres of government. That's the purpose of that particular position. Now, just as a way of...
If you could just pause for a second, Mr. Mathebula. You speak of all spheres of government. That would not include state entities, SOEs, etc. Just in that context, when you say this, over the spheres of government.
Currently, yes, all spheres. That would include state entities as well.
And you'll take the commission through when that position changed?
Exactly. I will take the commission as a way of background.
You can do so at the relevant time,
okay,
if you do not want to do it now.
All right.
Please proceed and just talk to the establishment of the office of the Chief Procurement Officer.
Thank you. The Office of the Chief Procurement Officer was established, of course, in 2013 by the then Minister of Finance. To ensure that there was transparency in the system and to deal, of course, with issues that related to the abuse of public procurement, corruption, fraud, and so on that was involved in them. That was part of the mandate, but the main mandate was to modernize the supply chain management system to make sure that it is effective and also efficient. That was the main purpose of the establishment of this office. And I'm sure it's now an open secret that there was, of course, a former chief procurement officer who is since not with the Treasury anymore, but I am acting in that position. So that was the role and the rationale behind the establishment of the Office of the Chief Procurement Officer. But this, of course, was to ensure that all spheres of government, I must say this, and government institutions would be regulated insofar as procurement is concerned through this particular office. And that's the role that this office is playing currently, oversight over the public processes in government.
Mr. Matebula, there are those who have the view that it's a standalone office, that is the Office of the Chief Procurement Officer. Is that correct? Where does it get its mandate from? How does it fit into National Treasury?
The OCPO, as we know it, the chairperson is one of the divisions within the National Treasury, and it reports to the Director General, who is an accounting officer at the National Treasury, and of course the Director General reports to the Executive Authority, who is the Minister of Finance at this point in time. So it is not a standalone department. It reports to the Director General.
Yes. Can we move on and deal with specifically the summary you have given under context, in particular the source of the mandate on procurement in government? What's the source of that mandate?
Yeah. I think we are one of the lucky chairperson countries in the world because procurement is embedded in the constitution of this country. Section 217, which is part of Chapter 13 of the Constitution that deals with financial matters. Hence, procurement is also an integral part of financial management. So that's where we draw our authority from, and that's where procurement comes from. The Constitution is an overarching kind of authority over procurement. And of course, out of the Constitution, we have the Public Finance Management Act. We also have the Municipal Finance Management Act. We also have the Procurement Policy Framework Act, the Preferential Procurement Policy Framework Act, from which we draw the authority in terms of procurement in this country.
Can I just take you back to your paragraph 2.1? And here you speak of government being the single largest procurer of goods and services. You deal with the policy decisions of government to leverage public procurement. Take the Commission through this thinking.
Thank you, Chair. It is correct that government is the biggest, single biggest procurer of goods and services in the country. That's a known fact. Now, given the size of public procurement, of course, government took a policy decision to leverage public procurement to support the achievement of broader socio-economic objectives. And the number of these objectives, you have black economic empowerment, which is part of this, your small business development, industrial development, etc. It's quite a number of objectives. However, the size of government procurement spend does give rise to the unintended but considerable potential for abuse of the system. The Constitution provides that when organs of state procure goods or services, they must comply with the principles of fairness, equity, transparency, competitiveness, and cost effectiveness. This means that organs of state must have reference to the above imperatives when procuring goods and services. As indicated earlier on, that Section 217 actually provides the basis for these imperatives, the 5 pillars. The aim, of course, should be to ensure that the attainment of value for money, that is the public money, should be spent in an effective and efficient manner. In addition, those who participate in competitive bidding processes must be treated fairly and without bias. That's the basis of Section 217(1). However, Chairperson, I must hasten to also indicate that there is Section 217(2) of the Constitution. And also Section 217(3), which are equally important and relevant in giving effect to the constitutional imperatives that mandate a public procurement function. The use as a base of open public tenders is generally regarded as the best practice. I mean, here in South Africa and all over the world, that's the basis. Dealing with public money, public funds. Therefore, when we're procuring goods and services, we should do so in an open, competitive process. In the case of South Africa, the use of open competitive bidding process is considered the best way to ensure compliance with the imperatives in Section 217(1) of the Constitution. And these underscore what is best practice.
Can I ask you to pause for a minute and apply your mind to this question? Are you able to give us an estimate of the size of, in money terms, of government's procurement spend? You may want to locate it in a particular sphere. You may want to go broader than that, just to give us a sense
Of
annually.
Okay. Thank you, Chairperson. The estimated procurement spend in government is just in excess of 800 billion for goods and services. That's the figure that we're talking about, and on an annual basis.
Yes, thank you. Proceed. You were just going to finish off with paragraph 1.7.
Yes. I wanted to say, of course, as indicated earlier on, the PFMA together with the MFMA provide a legal basis upon which a comprehensive oversight function is created. The procurement system in South Africa is underpinned by the Constitution as indicated, the PPPFA, the PFMA, and the MFMA. Although there are other pieces of legislation that have an impact on procurement, it must be noted, however, that even these prescripts, this piece of legislation, must conform to Section 217 of the Constitution.
Yes. Can I then ask you, Mr. Mathebula, to speak to us about what you refer to as the procurement architecture that you oversee?
Okay. Thank you, Chairperson. The architecture of the procurement system in South Africa could be described as a center-led system. So in other words, the policy development is centralized, whereas the execution of the policy is decentralized. So policy centralized within the National Treasury, we determine the broader framework, but the execution of that framework takes place in a decentralized format. So government departments, government institutions, public entities develop their own individual supply chain and procurement policies, but within the broader framework, which is centralized. And that is why every department has its own SCM policy, which takes its cue from the broader framework, and of course, to the PFMA, MFMA for local government, and the Constitution. So that's the architecture of this procurement system. Now, earlier on, Chair, I spoke about transversal contracts, and I think I must go back to this particular issue. To say the National Treasury currently does facilitate the arrangement of the transversal term contracts, as indicated earlier on, that you put together the volumes and therefore go out into the open market to derive economic benefits and out of economies of scale. So, but however, the day-to-day procurement of goods and services elsewhere, outside the National Treasury, is conducted through the SCM units. These are supply chain management units within individual organs of state, entities, public entities, and departments. Now, the distinct rules that govern individual procurement are formulated at an entity or department level as part of the supply chain management policies. And these are the responsibilities of the entities' accounting officers in the cases of government departments, and the accounting authorities in the case of public entities, because you're talking about boards. However, these accounting officers and authorities are also tasked with the responsibility to ensure compliance with the rules of the game as set out in the broader framework.
So when one looks at the history of procurement prior to the PFMA and the triple PFA, we had the State Tender Board Act. Where are the differences between what we had under that regime and this regime where you have devolved decision-making to entities lower down the trail from National Treasury? Just draw those distinctions.
Okay.
And explain why there was this change from the State Tender Board regime to the current PFMA, triple PFA regime.
Okay. Thank you, Chairperson. I think I must just spend some time here so I explain this particular issue properly. Now, in 2001, there was a division within Treasury, just as a way of background, whose mandate was to replace the outdated rule-driven procurement and provisioning system under the now defunct State Tender Board, and replace it with a new procurement system in keeping with the Constitution, the triple PFA, the PFMA, and later on in 2003 with the MFMA. So one would always recall that the State Tender Board Act itself was enacted in 1968. This is years before the Constitution. And surely the State Tender Board Act was inconsistent with the Constitution. And this is one of the reasons why the shift from the State Tender Board framework to the public finance management system. That's one reason, the first reason. The second reason is that the State Tender Board Act in itself conflicted with the PFMA, because the PFMA was enacted in 1999, and the State Tender Board Act was still in operation at that particular time. So you had the PFMA that granted powers to accounting officers and accounting authorities to manage procurement. But at the same time, you had the State Tender Board, which was a body that would come every 2 weeks, and they sit at National Treasury and to adjudicate on tenders from Cape Town to Messina and vice versa. Now, the problem was that the service delivery was impacted because this was a body of men that would come and ladies would come and sit there and adjudicate. And if they don't adjudicate favorably with the recommendations of various state institutions, now the decisions of the board had to be communicated back to those departments. And you can imagine the delay. And this was done through, and by the time we received clarification, service delivery was impacted. So that's the reason why the State Tender Board had to be phased out. By the way, although the State Tender Board Act exists in the statute books, the board itself was dissolved finally by the Minister of Finance in 2008. And equally, the provincial tender boards, who were also existing at the time, were dismantled to make way for managers, accounting officers, accounting authorities to take the responsibility in terms of procurement decisions and manage their entities. That's basically the difference between what has happened. So accountability as we speak now vests with accounting officers and accounting authorities. That includes, of course, the procurement decisions, apart from other decisions that accounting officers and authorities are responsible for.
I suppose one can also assume that this decentralized approach that was adopted in the PFMA and later legislation really was also aligned to the change in provinces after 1994, because then you could actually devolve decision-making more readily to the 9 provinces as opposed to what the old South Africa might have had. So all these statutes were really trying to align a new way of thinking. This is what I would surmise. Is this correct?
Through you, Chair, it's correct, because there was a PFMA which, whose letter and spirit, of course, advocated for the devolvement of powers to accounting officers and to all the regions to make their own decisions. On the other hand, you had the State Tender Board, which was centralized. Decisions were taken at a central point. So then the decision was, of course, to align the procurement system with the PFMA and also the Constitution. So the State Tender Board had to give way to accounting officers to make those decisions in various regions of this country and at all spheres of government. I think the MFMA, of course, applies at local government sphere.
With the problems that have beset government in relation to the abuse of these powers that have been devolved, are there any elements within the old State Tender Board Act or system that might still be of some value to the South Africa of today? I ask you this just in the context of widening the debate around how to stem the abuse that all of us know has been taking place in different forms, really. I'm not even talking about state capture, just generally irregularities that occur.
Yeah. Chair, I think we are fortunate in the sense that the State Tender Board Act, I'm sure, has got certain elements that we can always draw from in crafting the new revised procurement system, as we are busy now with the review of the procurement system. There are certain useful elements that we can obviously draw from that system.
I note that under the heading legislative framework you detail a number of statutes. Maybe just give us the salient points around those and how these speak to one another. Alternatively, how you have oversight over what is done in terms of these pieces of legislation.
Thank you very much, Chairperson. An overview of the national regulatory landscape reveals at least 10 distinct pieces of legislation apart from the Constitution, dealing in direct and significant manner with the regulation of aspects of public procurement in general. These are the PPPFA, your Preferential Procurement Policy Framework Act, which is informed, of course, by Section 2173 of the Constitution. The Public Finance Management Act, as we all know with the PFMA, the Municipal Finance Management Act, the State Tender Board Act of 1968 that I've already alluded to, the Broad-Based Black Economic Empowerment Act of 2003, the Prevention and Combating of Corrupt Activities Act of 2004, the Construction Industry Development Board Act of 2000, the National Land Transport Act of 2009, the National Supplies Procurement Act of 1970, and of course, the State Information Agency Act. Now, all these pieces of legislation, of course, as indicated, must be consistent with the Constitution. And of course, the Constitution itself gives the National Treasury the authority to oversee procurement processes and to regulate procurement in the country. So these pieces of legislation are still subjected to the Constitution and, of course, by oversight, the National Treasury. Now, there are other procurement legislation which are specific to entities and sectors, industry or products. In addition, well, in greatly varying degrees of specificity, the procurement functions of particular organs of state and or in relation to the specific issues. These include the Financial Management of Parliament and Provincial Legislatures Act of 2009, the Road Traffic Management Corporation Act of 1999, the Armaments Corporation of South Africa Limited Act of 2003, that's AMSCO, the Administrative Adjudication of Road Traffic Offences Act of 1998, the Nursing Act, Public Audit Act, the Health Professions Act, the Housing Act, Disaster Management Act, and the Correctional Services Act. Now while these statutes regulate procurement across a range of organs of state, there are a significant number of statutes that deal with procurement by particular entities. And there are also statutes addressing procurement in relation to a particular sector, industry, or product, as indicated earlier on. Now, in most cases, these statutes prescribe procurement rules in addition to the rules that would apply to the procurement activities mentioned above, in terms of the more general legislation above. In some instances, however, the specific legislation operates to the exclusion of general rules, such as in the case of the Financial Management of Parliament and Provincial Legislatures Act, which governs public procurement by Parliament to the exclusion of the PFMA.
In fact, I know you've explained this to me, that in terms of the courts as well,
Yeah.
they too are excluded from the PFMA.
Yes.
Could you just take us through that?
Yeah. Chair, as indicated, courts and judicial officers are excluded from the Constitution.
I'm sorry, from?
From which part of, what part of the Constitution?
Section 217.
I'm sorry, can you just repeat? I missed something. You said the courts are and judicial officers are excluded from?
Yep, they are excluded. In fact, let me just rephrase, Chairperson here. Section 2171, on its own terms, does not apply to all organs of state as defined in Section 239 of the Constitution. Now, Section 239 of the Constitution excludes the courts and judicial officers. So that's the point that I'm trying to clarify. Okay.
Yes. So you do not have control as National Treasury, direct control over those particular areas
Yes, because
of government?
thank you, Chairperson, because they're not defined as an organ of state in terms of Section 239 of the Constitution.
Yes. You were also, in your statement, you also make the example of arms corps in paragraph 4.3.5.
4.3.
4.3.5,
Yes, just.
as being authorized to procure,
Yes.
because it's a particular type of state entity.
Yes. Thank you very much, Chair, through you. Now, as indicated earlier on, that the Armaments Corporation of South Africa Act, provides a procurement system for the procurement of defense material, and it's applicable to defense. Now, this particular act authorizes the corporation, that is ARMSCO, to establish a system for tender and contract management in respect of defense material. And defense material is defined as any material, equipment, facilities, or services used principally for military purposes. The corporation is also authorized to procure commercial material, that is goods and services, other than defense material, for the Department of Defense and or any other organ of state in terms of a service level agreement between the corporation and such organ of state.
Now, Mr. Mathebula, just explain this to the chairman. What then is the control or the oversight role that National Treasury would have in those circumstances?
Yeah. As indicated earlier on, all these pieces of legislation are subject to the Constitution, Section 217, and also are subject to the PFMA, which grants the National Treasury an oversight role insofar as procurement is concerned. So that's the role that we're playing, in as much as these pieces of legislation exist, but they exist within the Constitution, and the PFMA takes the precedence over some of this. And that is where the Treasury then is responsible to regulate, to make sure that all these pieces of legislation conform to the principles of fairness, equity, cost effectiveness, competitiveness, and transparency.
Could you then proceed to take us through your submissions in paragraph 4.4 of your statement?
Chairperson, there are other laws which are relevant for procurement. And they're very important when dealing with procurement. And these are PAIA, as we know it, PAJA, and also the Local Government Municipal Systems Act of 2006, of 2000. So they're also very important because they form part and parcel of the procurement processes.
Mr. Mathebula, you have made reference to the Constitution, and in paragraph 4.5, you then take the stance that there are particular reasons why the Constitution really is framed, certainly Section 217 is framed in the manner that it is. Please take us through that thinking that you've reduced to writing in 4.5.1.
Okay. Chairperson, as indicated, the Constitution is the authority over procurement processes in the country, Section 217. There are a number of reasons why special and fairly detailed attention needs to be given to the Constitution in setting out the regulatory regime applicable to public procurement in South Africa. The first reason is the supremacy of the Constitution, which has the result that all other law is subject to the Constitution's prescripts and must be formulated and interpreted in a way that accords with the Constitution. The second reason is that the Constitution expressly creates the foundation for public procurement regulation in South Africa. A third reason is that while the Constitution provides the supreme basis for public procurement regulation, it does so only in broad principled terms. To the extent that the public sector relies on public procurement to give effect to this constitutional mandate, the Constitution is thus of much broader relevance to public procurement generally than simply the provisions dealing specifically with public procurement regulation. The Constitution contains a number of provisions that can be viewed as creating the framework for public procurement regulation. Now, given the pervasive nature of public procurement involving, in essence, all state functions and all public institutions, it follows that the vast majority of provisions in the Constitution are relevant to public procurement in one way or another. For example, since the public procurement necessarily involves the spending of public funds, the whole of Chapter 13 of the Constitution is relevant. Likewise, since public procurement is inevitably tied up with public administration, the whole of Chapter 10 of the Constitution is of relevance to public procurement. Now, however, if one focuses on those constitutional sections that can be said to govern public procurement in a specific way, to the extent that they may be viewed as facilitating the regulatory regime applicable to public procurement, the following constitutional provisions are of direct relevance. Section 217 of the Constitution, Section 33, which sets out the basic requirements for constitutionally valid administrative action, and consequently, the grounds upon which administrative action may be reviewed by the courts of this country. And of course, Section 195, which sets out the constitutional values for public administration in South Africa.
If you would then, Mr. Mathebula, just speak to the issue of the scope of the application of Section 217, with emphasis on what you have referred to as entity, involvement, and transactions concluded. You find this on page 11 of your statement.
Okay. Thank you, Chairperson. The scope of application of Section 217 is determined by two factors. One, the entity involved, and two, the transaction concluded. Now, we've spoken about this earlier on around how does it cover organs of state that are defined in Section 239 of the Constitution, and also those that are not covered in terms of Section 239. Now, if I may, with your permission, Chair, just deal with Section 33. Yeah.
That's fine, Mr. Muthu.
Is that okay?
Proceed.
Yeah. Thank you, Chair. The second constitutional provision that is of particular importance for public procurement regulation is Section 33 of the Constitution, which sets out the fundamental right to administrative justice. Section 33 requires all administrative action to be lawful, reasonable, and procedurally fair. Section 33(2) grants a person affected by administrative action of public functionaries the right to written reasons for such action. Maybe I should end here, Chairperson, and not further elaborate on what Section 33 provides. But of course, it is the basis for the Promotion of Administrative Justice Act, as we know it, PAJA. And Section 195, which is another section, the final constitution section of particular relevance for public procurement is this particular section, Section 195. This section sets out the basic values and principles governing public administration in South Africa. Now, given the centrality of public procurement in public administration, it follows that this section is also a foundational importance for public procurement. Moreover, among the values and principles listed in Section 195, there are a number of that are particularly apt in a procurement context. And I can go on and talk to them, but I mean, it is also clear in Section 195. I may just end here for now.
That's quite in order.
Yes.
You have mapped out the broad landscape of Section 217 of the Constitution, Section 33, Section 195 of the Constitution, and given the Commission a view of how these are integrated, how these are aligned. But of course, what flows from that is what you have here in your statement referred to as the specific regulatory instruments. And one of the most central ones is the PPPFA. Could you please, within the context of the work of this Commission, help the Commission understand why the PPPFA is such a central piece of legislation?
Thank you, Chairperson. The PPPFA, or the Provincial Procurement Policy Framework Act, is directly informed by Section 2173 of the Constitution. Section 2171, of course, lays those 5 basic principles. But Section 2172 provides that there is nothing prohibiting organs of state from developing a procurement policy that would take care of those who were historically disadvantaged by unfair discrimination in the allocation of government contracts. That's what 2172 says. And of course, 2173 talks about this national legislation. And this national legislation that we're talking about is this PPPFA. It is directly from the Constitution. Now, as with the PFMA and MFMA, the PPPFA mandates organs of state to formulate their own preferential procurement policies and to procure on behalf of those policies. However, the PPPFA significantly narrows down the scope for variation in individual preferential procurement policies by providing for a set framework within which individual policies must be formulated and procurement be done. Now, this framework essentially prescribes a preference point system for adjudication of contracts and tenders, in terms of which certain categories of bidders are given preference, applies to bid adjudication in general, and is thus not restricted to only the preferential dimensions of public procurement. Now, the preferential point system in terms of this act prescribes in a 90-10 preference system where the 90 are points for price and where the 10 are points for preference to advance the historically disadvantaged individuals. The 80-20, also the same. The 80-20 preference system, the 80 being the price, the points for price, and the 20 being points for the preferences that are allocated. And then when you take the 80 and the 20, the 80 and the 20 together, then you come out with a total number of points. And of course, the same with the 90-10 preference system. However, Chair, I must also hasten to say that whilst we take this particular preference system into consideration, there are also other special conditions that those who bid for government contracts must comply with. You've got functionality, the technical competency of the bidder to render a service in terms of a particular contract. So you take all these together, and then you come out with the highest scoring bidder who should be awarded a contract.
Mr. Matebula, because this is one of the areas that some people identify as the soft underbelly of procurement, maybe it would be useful if you could take us through the criteria that would ordinarily be applied when setting up a bid evaluation committee and a bid adjudication committee, because these are the instruments that are used when this preference is allocated.
Yeah. Thank you, Chairperson. The SCM now, I think I must just explain this, because the supply chain management system is regulated, of course, through the PFMA and the MFMA. And these are the two pieces of legislation that prescribe how bid committees should be constituted. Whereas the PPPFA talks to how preferences should be allocated to advance historically disadvantaged persons. Now, the committees, in terms of the Treasury regulations, there are three types of committees. And that's what the SM system prescribes. Your first committee is what we call the Bid Specification Committee. And this is a committee that sets the technical specification of what is needed. Whatever you want to procure must conform to certain technical qualities and characteristics. And this is the committee that sits and decides these are the needs from a technical point of view. And it's a committee that should be constituted by the user departments when they want to procure goods and services. Their role ends at the design of the technical specifications. Then there is another second committee, the Bid Evaluation Committee. This is a committee that comes after a bid has been published and received. Their role is to evaluate that bid. And we prescribe in that at least these committees must be cross-functional in nature. In other words, you need to bring in different skills in that committee to draw at least expertise from various skills. However, we also go on to say, the prescripts go on to say, in all these committees, there must be a supply chain stroke procurement person. Their role is to evaluate the bid in accordance with the criteria set in the bid specification committee and also as advertised, and produce a report, whether they recommend or they don't recommend. And then they send their report to another committee, which is a bid adjudication committee, whose role, of course, is to adjudicate on that particular bid depending on the delegation. If that bid adjudication committee is fully delegated to make a final decision, then they do so. However, if they don't have that full delegation, then they make a recommendation to the accounting officer or the accounting authority in the case of boards. And then it is the responsibility of the accounting officer and the accounting authority to make a final decision in terms of the recommendation of the bid evaluation committee. Again, in these committees, it is prescribed that they may draw as observers independent experts, but the role of experts is simply that. They provide advice, but they can't take part in the final decision-making of a particular contract, because that would then conflict with the accountability principle, which currently vests with accounting authorities and, of course, accounting officers. They sit there, they advise, and thank you, they leave. That is the observers and the experts in terms of these bid committees. So this is what is prescribed in terms of the rules of the game.
You see, you set out what is prescribed, as you put it, in the rules of the game. But we know just from the number of court applications that have taken up much of our court's time, that there's either a systemic problem, or it's the way the committees are constituted. There is a problem that leads to irregularities. Are you able to help this committee, this commission, understand where those issues arise in relation to these institutions or these tools that are supposed to have these Chinese walls, that are supposed to be impartial and apply set criteria, yet for whatever reason do not do so?
Chairperson, I'm not so sure if I can answer, but I think I understand the question. There are a number of reasons. Some of the reasons, let me just state up front, some of the reasons could be intentional, to abuse the system, but some of the reasons could be the interpretation of the application of the rules of the game. Of course, based on the capacity, because procurement as a system in itself does not have a professional kind of that professionally. You still, and you throw anybody can come and procure. You throw an HR person who may not have had a job in HR, and then you throw him into procurement. And these people do not understand the rules. But if you look at what has been happening in the past years, I'm sure one could always ascribe at least more than 50% of these infractions to intentions to abuse the system.
Chairman, I notice it's just about 11:15. Might this be a convenient time to take the tea adjournment?
Thank you. We'll take the tea adjournment until 11:30.
Thank you very much, Blaine. This is a very technical evidence by Willie Matebula, who is the acting Chief Procurement Officer in the Treasury. He's basically telling us how it all functions. But what we can perhaps take out of that is that he's saying the government annually spends about 800 billion rand. And that the fact that the government spends so much, necessarily there could be people who may want to flout the processes. I mean, he was saying the rules and the guidelines are there and they are tight. But the fact of the matter is that individuals would always come out with their own ways of really perhaps trying to trick the system. So I think as he continues with his testimony, I think he will also delve into the issue of the issue of the deviation, because I think that's where perhaps some of the wrongdoing are naturally found, where people don't have to go through proper processes because they are allowed to go for what is called deviation, where they can grant a contract without any certain procedures being followed. So yeah, it's very technical at this stage, and then we will really sit and listen and hear as he's being questioned as to what exactly else the Treasury is vulnerable to with regards to people trying to manipulate it.
Yeah, at the very onset, at the beginning, it was said that his testimony statement will not implicate anybody, isn't it? It's just about giving context.
It's just about giving context, and I think it's really helpful because it will help in the event where people really did things that are wrong. So what he is doing, he's setting out the foundation as to how Treasury operates when it deals with issues of contracts. But then there are individuals who are responsible for dealing with all sorts of contracts. So you as we go forward, I mean, you will hear how people then would take a particular contract and give it to their friend, despite that the rules and guidelines are quite clear. So I think for me, what I'm really looking forward to here as he continues his testimony is the issue in the main of deviation, and I think that's the main issue that's going to come now, because once people are allowed to deviate from the normal processes, that's when they become creative and then manipulate the systems.
Yeah, and Zoe, give us a TikTok in terms of how the proceedings are going to go ahead. He's going to come back from tea. Any other witnesses likely to be called today?
At this stage, the Commission is very mum. They are not saying anything about the next witness. But if the process is going the manner in which it's going, we perhaps expect that maybe by lunchtime they would have concluded with Mr. Matebula. Remember, he is not implicating anyone. There will be no issues of cross-examination. So once he's laid out how the rules and the processes operate in the Treasury, and I think we'll then see the end of the day. But as I say, the Commission is very mum, so we're expecting that perhaps someone like Mr. Jonas and Fikimento could be next, but there doesn't seem to be any sign of that. And perhaps the indication is that we're looking at the legal representatives because we know who Mr. Jonas and Ms. Mento will implicate, and we are not seeing any of those legal representatives, so which does suggest that they may not be coming today. But after lunch or going forward, we don't know what's going to happen, Blaine.
So is there any particular reason for the Commission to be mum, be quiet about the lineup?
What we understood yesterday was that because they were still in the process of finalizing the issue of witnesses, and some are struggling with the issues of clearance, so there are still few issues that need to be cleared. But as far as the main issues of witnesses is concerned, those who have confirmed, I think it's a question of really aligning the timetables with the legal reps and those who will come and present their evidence.
Okay, let's leave it there. As always, we appreciate your reporting. Mzondile Mbeche, live for us in Parktown, Johannesburg. Let's take a quick break. The agenda will be back. Stay with us.
These are some of the ethical standards.
Can I ask you to pause just at that point?
Yeah.
What if I take a friend of mine from another board that I sit on with him or her and bring them to a board where I want certain things to go a particular way? Do the prescripts cater for that? Where friends or business partners or business people who share the same objectives in terms of what they want to do, bring themselves into the same fora where decisions on huge contracts are made.
Yeah. Thank you through you, Chairperson. Look, I'm going to go back to the principle of accountability. Now, the prescripts do not allow an external person to participate in the processes. So these are government officials who must be there, because otherwise, if you allow somebody outside of government, that principle of accountability gets lost, because then now it would seem like you are now subjecting the decision making to people who are outside, and therefore the accounting authority or accounting officers would not be in a position to make a decision. That is why earlier on I spoke about the fact that even if you get independent experts, their role is simply to advise, and that's it. But they can't take part in the final decision making. But what we do pick up is that some of these specifications, it's very important, that first part of the bid specification committee. Some of the specifications are crafted in a biased manner, because that's where it begins. If that particular area is not closed, then you may as well have lost the battle, because when it goes to the next evaluation and so on, already your specifications are tainted in one way or the other. And it's a very important committee, because the prescripts also prohibit drafting specification, for instance, around a particular brand or around a particular product. The specifications must be as generic as possible, and those that participate must be unscrupulous in their conduct in terms of procuring. So there's quite a number of these ethical standards that are prescribed that all those who participate must comply with. Now, whether you're looking at the PFMA or whether you're looking at the MFMA, whose supply chain management regulations, by the way, are even more detailed than you have with the PFMA, because the MFMA is a later legislation. So at least those regulations are much broader in terms of how they should actually apply. And now getting back to the question around an example made, the PFMA, Section 51(1)(a)(3) deals specifically with accounting authorities, with public entities. because it also prescribes the same principles that are, of course, encapsulated in the Constitution of fair, equitable, competitive, transparent, and cost-effective. I mean, that's what it says. The accounting authority of a public, the account of a public entity must have a procurement system that is fair, transparent, equitable, competitive, and cost-effective. So when one looks at public entities, especially these are your Schedule 2 public entities. These are big public entities, by the way, which we now came to know as SOCs, or commonly known as SOCs. They are listed in terms of that particular schedule in the PFMA. Now, if you look at the SCM, the Treasury regulations, which were issued in terms of Section 76(4)(c) of the PFMA, that Treasury regulation, the Chapter 16A thereof, which deals with SCM issues, currently it does not cover public entities listed in Schedules 2. These are your big entities, your Transness, your Eskom, your Denell, etc. SAFCOL, you name them. And also it does not apply to Schedule 3B and 3D to the PFMA. Now, the 3Bs are your national government business enterprises, and the 3D are your provincial government business enterprises. And there was a reason why in 2003, when we developed the Treasury regulations, specifically the chapter that deals with procurement, Chapter 16A, we excluded these entities. The first reason was that these entities, have got different governance structures. That's the first thing. So they are run by boards. Now you wouldn't want to box the board of directors and prescribe to them the rules, a rule-driven kind of a system, which is typical to a normal government department. So that's the first reason. Allow them flexibility, and the rationale was they will exercise their fiduciary duties correctly in terms of the PFMA. That's one, and because they're operating as different governance structures. The second part, of course, was the fact that these entities operate along commercial lines. So bottom line to them counts, in as much as they have a developmental mandate, but bottom line complies. That was the reason why they were left out of that particular chapter, 16A, in its current form. But of course, I think I will get to this point later on during my presentation, that we are now kind of trying to review.
Yes, because my next question was going to be, how then do you monitor them? Because all the other institutions are monitored under Treasury Regulation 16 Cap A. What happens in this instance? How are they held to account for the decisions that they take?
Look, in as much as the Treasury Regulation, which is a subordinate legislation, but the primary legislation, which is the PFMA, applies equally to them. So they can't escape, because we're using the PFMA, whilst the regulations themselves exclude them, but the PFMA does not. They still need to comply with the PFMA. And as custodians, of course, of the PFMA, we play that oversight role in terms of what they need to do. and the decisions that they take.
Coming back to the example I'd used earlier of Transnet, I could use Eskom, I could use Denell. Are you saying that their procurement systems fall outside of 16A?
Thank you, Chair. In the current form, yes, falls out of 16A, however, does not fall outside the PFMA. So the PFMA still applies to them equally. And we are, of course, the custodian of that instrument. So we apply it to them equally to make sure that their procurement system is fair, all those and transparent as well.
As the custodians of that system, have you had cause to conduct investigations as National Treasury into the irregularities that may have occurred in those particular entities? And I just happen to pick on 3 right now. It's Transnet, Eskom, Denell. There are others. I really just use those to illustrate the point.
Thank you, through you, Chair. Look, I think it's an open secret that, yes, of course, Treasury has commissioned some investigations into, irregularities, specifically in procurement of specific goods and services within some of these, large public entities.
In that instance, because this is the commission and we're trying to do a particular piece of work, are you able to tell the commission where it might get hold of these particular reports? Because by the sound of things, they could assist the commission quite significantly.
Thank you, Chair. I think we've taken a view, we've taken a position as the National Treasury that the Commission must be supported in all respects. And to that extent, all relevant reports that are in possession of the National Treasury would be provided to this committee, to this commission, to, of course, discharge its responsibility.
Is that via the DG's office or via your office?
Well, everything goes via the DG as the accounting officer. So we channel everything to the DG for consultation, and then it comes through to the commission through that particular route.
We have just touched on irregularities in SOCs and state entities, but there's of course also a multitude of problems in the other spheres of government. And I'm not exonerating national. The sense I get is that you think you are on top of what happens at national level. What is it that National Treasury does to monitor what goes on in the other spheres of government, and what steps are being taken to stem any possible abuse, any irregularities that are taking place in the other spheres of government?
Before you answer, Mr. Mathebula, please don't forget the question. I just want to say that whatever attempts may have been made during the tea break to address my difficulties in hearing counsel don't seem to have been successful. We are still in the same situation. I can hear Mr. Mathebula quite well, but there is difficulty hearing counsel. So if the problem is technical, then please, during the lunch break, try and address it. But in the meantime, we'll continue. It may be that it's not about raising your voice, but when you do raise it, it's better.
I will make a real effort, Chairman, to speak much louder. Yes.
I think what may be happening is what is natural. You would raise your voice, after some time it goes back to its normal level. But I suspect that the problem is may well be technical. It might not be your voice. You just do the best that you can without doing injustice to yourself.
It might also be, Chairman, that at my age, I think I'm speaking loudly while I'm actually whispering. So I will speak a little louder.
I don't know about the age part.
Thank you, Chairman. Mr. Mathebula, so the question really now relates to the other spheres of government.
Yeah.
How do you identify, how do you monitor, how do you try to stem irregularities that may be taking place there?
Okay. Thank you, through you, Chairperson. Look, there is a directorate, we say chief directorate, within the OCPO that deals specifically with irregularities and abuse of the system. That's one. But secondly, within the National Treasury as well, specifically within the Office of the Accountant General, there is a unit that deals with investigations. And of course, these units collaborate with law enforcement agencies, at least to deal with specific issues. The police, the hawks, and that's a process that has existed over quite some time. So that's what we do. We do reviews of the tenders that have been awarded by other spheres, especially where allegations are raised by interested parties, and then we move in there. We collect the documentation, we assess and analyze the documentation, and eventually make a determination what could have gone wrong. And of course, I think we are enjoined by the Anti-Corruption Act to report some of these cases to law enforcement agencies to deal with, and that's what we do. But beyond, just beyond just this particular part, we also realize that there could be some gaps in our own regulatory framework, and from time to time, we issue instructions, Treasury instructions, to augment the gaps that may be existing in trying to deal with these things. And there are quite a number of these instructions that have been issued over a long period since the introduction of supply chain management in 2003 to deal with issues of the abuse of the procurement system in the country.
I do want us to talk about deviations and contract variations, but before we get there, maybe we should just tidy up the whatever evidence you may want to give this commission on the preferential procurement regulations of 2011 and the ones of 2017, and explain why you decided to publish these and whether the objective you sought to achieve has in fact been met.
Chair, through you, the Preferential Procurement Policy Framework Act, the PPPFA, was, of course, enacted in 2000, and in 2001, regulations to that particular act were promulgated by the Minister of Finance. And of course, we've spoken about the objective of the PPFA earlier on. Now, these particular regulations, up to 2011, at least did not apply to, again, the public entities listed in Schedules 2, 3B, and D to the PFMA. It only applies to provincial and national departments, constitutional institutions, as well as public entities listed in the Schedules 3A and 3C to the PFMA. Now, in around 2009 and 2010, there was a discussion with social partners at NEDLEC. I mean, given the procurement spend by these large public entities, to say they need to be brought into the picture within this legislation to ensure that they assist in the achievement of government social economic objectives that we spoke about earlier on. So that's one part. But the second part was to say Cabinet has, of course, ruled that the triple PFA and the triple BEE, this is your Broad-Based Black Economic Empowerment Act, these two acts were not aligned, so they were not talking. So you had the triple PFA that went this way, and then you also had the triple BEE Act which went that way. Now, given the importance of the Broad-Based Black Economic Empowerment Act, so then the decision was to say these two must be aligned, so that when we award contracts and tenders, we also take cognizance of the provisions of the broad-based black economic empowerment to make sure that there is a transformation in the country. Now, that's the purpose why the 2011 regulations were promulgated, but that's not the only one. Of course, the other was to say the South African market was, of course, the economy was bleeding in the sense that we had a lot of imports which flooded our economy, and as a result, there were issues around job losses, etc., and some companies in the country were closing down. So when that decision was taken eventually during the discussions with social partners at NADLEC, then we decided that that should also be part of this alignment. Therefore, the 2011 regulations introduced what we called local, product, local content and production, to make sure that we favor locally produced goods, the South African proud SA goods, to make sure that we retain jobs in this country, apart from the fact that we needed to transform. So these are the reasons why we came up with the 2011 regulations. Now, if I were to answer whether were we successful, yes or no, in terms of the objectives, I would say yes, in the sense that, yes, to some degree, in the sense that the Department of Trade and Industry, together with the National Treasury, have used these particular instruments, the 2011 regulations, to designate certain goods, and certain sectors of the economy for local production. Because all tenders now that had to go out had to have at least a provision that in a particular designated product, those goods must be procured in the country. I can just give an example. If you look at the textile, if you were to go to all those instructions, the textile industry has been designated 100%. So in other words, what government procures insofar as the uniform of police, of defense people, the prisons, all that we procure in terms of that particular sector, clothing, leather, and footwear, that particular sector is designated 100% locally. So if you can't find at least the material in the country, then you have to get, of course, permission from the DTI to go and import elsewhere. But production must still take place within the country to make sure that there are jobs. So some of these sectors have been designated, 100%, like this one, some are 70%, etc. There's quite a number of them. And we monitor together with the DTI to make sure, and of course we are also helped by the public when they see tenders that are published and without this particular condition, to make sure that at least we comply with this particular condition. That's one part, Chairperson. The second part, which I can say, I can't say confidently that we have managed to achieve, is on the transformation part. Why I'm saying so? If you look at the PPFA in its current form, in the Act itself, it prescribes the 80-20 and the 90-20, the preference systems. So the public has been, of course, raising issues, and I think we're the first one within the National Treasury to admit that indeed there is a shortcoming, to say, but this particular piece of legislation does not go wide enough to address transformation. So whichever way you do, whether you try to massage the regulations as we did in 2011, but because of the fact that the 90-10 and the 80-20 is included in the primary legislation, which only Parliament can change, it was difficult to say, let's move. Some people would propose and say, let's go 50-50. In other words, 50 price and 50 transformational preference points. But so these are debates that at least we grappling with as we speak now, and which we hope that it would be addressed sooner than later. Of course, we've heard South Africans, we've heard what they're saying, and we're taking a position to address that particular issue. So whether you have the 2011 regulations, but you're still sitting with this 80-20 and the 90-10, that sits in the primary legislation, because you can't change the primary legislation through the subordinate legislation. So that's the challenge that we're having currently. That's just the one part that I think we still have got a long way to go to make sure that we live up to what the broad-based black economic empowerment, requires of us to do. Now, just lastly, I think I must also state that the BBEE Act talks to transformation of sectors and, of course, industries, and also the patterns of ownership in terms of the business in the country, whereas the PPFA addresses preferences. So we allocate preference because you are a level 4 or a level 3 or a level 2 a company or a level 1, etc., etc. I mean, these are some of the things that we're grappling with, but I'm sure in no time we will be on top of this particular challenge.
I have focused quite a bit on your oversight role and your monitoring role. But I know in terms of the PFMA, you also have an enforcement role.
Yes.
And that's also of interest to this commission. How do you implement that role? Because it would appear that very few people suffer the consequences of the transgressions that have come up in the public arena, in public debates. So enforcement, talk to us about enforcement of these prescripts by National Treasury? And maybe you should just break it down for the chairman. Maybe we should look at national, the three spheres, and then if you could then deal with the entities as well as a separate category. What is your role in terms of enforcement?
Okay. Chair, Section 6 of the PFMA is quite clear on the roles and responsibilities of the National Treasury when it comes to enforcement. And the same provisions of Section 6 are repeated in Section 18 of the PFMA for provincial treasuries to assist in terms of enforcement. And also the MFMA, has provisions to make sure that the National Treasury enforces this piece of legislation. The powers of the Treasury are quite clear there. As indicated earlier on, where we pick up gaps, especially where there are irregularities in the system, we issue instructions to augment the system. But the question is, are instructions on their own enough to address some of these things unless you address the behavior of the people that are dealing with procurement to make sure that they live up to what the Constitution is saying. We have, of course, a number of divisions within the Treasury. All of us together enforce certain parts of the PFMA and the MFMA. However, this still remains a challenge. I must say that a challenge, it's a war that we're fighting to make sure that there is no abuse of the system. But of course, as you may know now, that there are still these elements, much so embedded in the system, for intentional abuse of the system.
Yes, which is why the question is, where you recognize and identify that intentional abuse of the system, what steps do you take? You can use any example to illustrate the point. What is it that you take? And the reason this is important is because the chairman at some point will be making recommendations on a variety of things. Maybe this is an area that this commission needs to explore in detail, so that when recommendations are proposed to the chairman, he has an appreciation of where the problems sit.
Okay. Chair, in terms of our action, we've done this over the years, even during the State Tender Board, save for the fact that the State Tender Board was inconsistent with the Constitution. So when we pick up abuses of the system, there are processes prescribed in terms of the public service regulations to deal with officials, because the accountability vests with accounting officers. That's one process. To take disciplinary measures and so on against the perpetrators. That exists. But the second part is when we pick up that there is a problem, we have one of the following. We investigate, we cancel the contract. Of course, you apply rules of national justice. Cancel the contract. We also restrict, in extreme cases where there is, we restrict suppliers from doing business with government. I know in the past, during the State Tender Board era, some of suppliers and even persons individually were sitting in our restricted list indefinitely, because that's what the State Tender Board Act says. We could restrict you indefinitely, which I think was a bit of a problem, because there is no individual person that must be sanctioned to perpetually. So, but currently what we do, because we take our cue from the Anti-Corruption Act, the Combat Anti-Corruption Act, at least it sets a limit in terms of the period, for which a particular supplier or individual must be restricted from doing business with government. Now, there's a shortcoming though, that's one part, but there's another part that has to be sanctioned by court. So there are two lists. There is one list that as National Treasury we put together and we place people there. That's one list. But there's another list called defaulters, those that default. But that, of course, has to be sanctioned by court, because we pick up this information, we send to court, and court would then endorse and say, that particular supplier and those people must be endorsed on the register for defaulters. Now, there is a slight challenge in both processes. We are not experts, especially when it comes to the register for tender defaulters. We are not experts in sentencing. So courts have at times simply said, no, it must be endorsed, but they don't, of course, indicate for how long. Now we sit and we decide, which I think that's what, and we decide out of our own to say, I mean, the transgression may be, I mean, the sanction may be commensurate with the transgression. And then we decide we give you 5 years. For 5 years, you are barred from doing business with government. But whether that is fair, we don't know. So, but that's a shortcoming in our process for both restricted list as well as where court sanctions and endorses that people must be on that list. So we would prefer at least a system, I'm sure, where at least courts take both this responsibility of endorsing as well as sentencing, to say for how long. But the Anti-Corruption Act at least is a guide in our case, because it says no more than 10 years.
Now, in the response you've given the chairman, I understand that within the 3 spheres of government, does the same response apply to SOCs and other state entities? Are they monitored in the same way? Do the same enforcement rules apply to them?
Yes, it is correct, Chairperson.
Which particular office within National Treasury keeps a schedule of these transgressors? Is that you actually keep a record, an annual record of what you've investigated, how many people have then been prosecuted, or what enforcement measures have been taken against particular people?
Thank you, Chair. Those that are investigated by the Office of the Accountant General are kept by that office. And those that are investigated by the Office of the Chief Procurement Officer are kept by that office. So the stats in terms of what happened, we keep differently, because the OAG also receives quite a number of, and they're involved in quite a number of investigations, similarly to ours.
And then just to recap, you have suggested that we speak to the DG in relation to getting these reports, because he can then coordinate the various sources of reports, whether it's statistics or any other investigative reports.
Yes. Yes, Chairperson, that's correct.
Can I then move to the question of deviations? Deviations form a substantial part of your statement.
Yes.
And deviations and variations and expansions of contracts really are two sides of the same coin in a sense, because they're again another weak link in the manner in which procurement is monitored by yourselves. Please address the question of deviations as fully as you can and deal with the exceptional circumstances. But in doing that, deal with the deviations from those exceptional circumstances, if I might use the same term.
Okay. Thank you, Chairperson. Deviations are actually allowed in as much as Section 217 says, but practically, there are instances where, organs of state are allowed some kind of degree to deviate from the procurement processes. But then there are instances, the first instance is it must be on an emergency basis. For life-threatening situations, cyber security crime, which threatens national security, fire, and all those instances are classified as life-threatening. So you can't be expected to go out on an open competitive period over 30 days to make sure that you address that particular issue. That's an emergency. That's how we define emergency. Then you are allowed to deviate. But I'll come.
Can I ask you to pause there? Is
Yeah.
it defined in the prescripts?
Yes.
Which particular prescripts?
This is defined in Treasury Regulation 16A 6.4 and also in the MFMA, as well as in a number of instructions that I will talk to.
But would those apply to those SOCs who we earlier agreed are not governed by Treasury Regulation 16 Cap A?
Yes, Chairperson, they would apply, and I'll explain why, if you allow me. So the first part is emergencies. The second part is sole source statuses, where you are allowed to dispense with a competitive bidding process. It's a sole source. I mean, in this country, it's a known fact that over a period of time, we procure electricity from Eskom. So why would you expect an open competitive? There is one supplier for electricity in the country, and therefore it's Eskom. So in those instances, the prescripts do make provision for dispensing with a competitive bidding process. Now, when we made this provision in the Treasury Regulation, immediately thereafter, we then pick up pockets of the abuse of this particular regulation. And we issued an instruction to say, look, if you deviate from a normal procurement process, other than in case of emergency or sole source, and the transaction is above $1 million, please report to the AG within 10 days. And also the reasons for deviating from a normal procurement process must be recorded by the accounting officers for audit purposes. That's one instruction. But this thing, went on. People started to make use of this because, that's an instrument that's there. Then we again issued another instruction that prescribed certain thresholds within which people could apply this particular provisions, and not losing that it's on the basis of emergency and sole source, not agent. Because I know some institutions would always say, no, this is agency, confusing emergency and agent. And agency. And in recognition of the fact that you would find instances where a contract starts at 4 million And by the time you know it, the contract value is sitting at 200 million. And you ask yourself, how is this possible? Then we issued an instruction in 2011, May 2011, to deal specifically around these issues, where we're prescribing exactly in what instances should the contract expansions and deviations be allowed. In the case of the expansions and variations of contract, we then prescribe that for your normal goods and services, a contract could be varied by 15% or 15 million, whichever is the lesser. Okay. And then for construction-related procurement, we set the threshold at 20% and 20 million, also whichever is the lesser of these amounts. So that was an instruction that we issued in 2011. Of course, the instruction issued in terms of Section 76(4)(c) of the PFMA. Then, in 2016, there was another instruction that we issued, 2016-17, to combat procurement abuses. And this particular instruction also highlighted exactly the same principles, save for the fact that this particular instruction went a step further and say any other deviation outside of emergency and outside of a sole source must be approved by the relevant treasury. When relevant treasury would refer to national treasury and provincial treasuries. And I think the intention was quite good because you wanted to make sure that all deviations come to treasury and the relevant treasury approves. That was the intention, to combat. And the second intention was to make sure that the system becomes transparent, because already we knew that in as much as some of the public entities were not covered by our regulations, but these practices were happening in any event. So, but there were unintended consequences. I think this is quite important, in the sense that instead of deviations being an exception from the norm, deviations became the norm. So, organs of state, instead of complying with Section 217, saw a room to use deviations to circumvent the system. And this is where the challenge is. Remember, deviations by their very nature, if you say to me, I must deviate from a normal procurement process, you're actually giving me a blank check. Because then I decide, who do I award the tender to? It's given to me, I decide, I can give it to anybody. I think that's just the unintended consequence of a very good intention in terms of that instruction. So I think, let me stop here for now in terms of deviations, Chairperson.
Who has kept a record of those deviations, if there is one at all?
Thank you, Chairperson. The Office of the Chief Procurement Officer keeps the record thereof, and all deviations approved or not, supported or not supported, are published on our website. So it's a publicly available information on our sub, you can see which entity applied for which deviation and what was granted at the end of the day, and even the estimated value of a deviation, because deviations are based on a project or a contract. And that information is readily available. We provide it from time to time to Parliament, of course, and it is a published information. It's available.
Back to the question of enforcement. What do you then do where you have found deviations that are outside of the prescripts of National Treasury? Consequences.
Before you answer, Mr. Mathebula, just so that in case somebody has done something, then they know it's working. Right now, I can hear you very well.
Thank you, Chairman.
Yes, you may answer.
It's enforcement consequences. We go back to that question.
Yeah.
What happens to those transgressors?
You know, it's one area, Chairperson, because when we report to Parliament, and then Parliament plays its oversight role, you may have seen that a number of these entities and government departments over the last while have been appearing before Parliament for consequence management, because that's what Parliament is there for, to play the oversight role. We go to Parliament, of course, to support Parliament in its work when these departments and entities are hauled before Parliament to answer to some of these things as we speak. It's an ongoing process to make sure that there are consequences.
Again, I simply go back to the State Tender Board because it's a regime that we had and that one can use just to compare where we are. Variations of contracts, deviations. How were those dealt with under that regime? And you can see my train of thought is I'm already thinking, is there anything that this commission can recommend in terms of strengthening and improving the prevailing framework?
Thank you, Chair. The State Tender Board, as indicated, also did deal with contract variations, but to reasonable degrees. Because the board would simply say, okay, if there is an application for a variation of a contract, firstly, the board would ask questions. Why was there variation in the first place? Because government departments are supposed to plan. So lack of planning, of course, should not be used as a reason for varying contracts. So it dealt with those issues, but very carefully, in the sense that the State Tender Board would simply say, okay, we're giving you a variation, but based on certain conditions that institutions have to apply to comply with. I know they would, for instance, they would say, we're giving you this on a month-to-month basis, but not exceeding X amount of period. So within that period, so in other words, your contract extension should be on a month-to-month basis, but not exceeding X period. If for whatever reason, departments failed to comply with that, they could either come back to the board, provide reasons, or the contract expires, and then the department would be sitting without, and then they were given what we call delegated powers, where they could procure through their own delegated powers, which of course were delegated to them by the State Tender Board, pending the finalization of their own contracts. And the board would always follow some of these contracts, because remember, all procurement was under the auspices of the tender board. So there was a record of what has happened, what decisions were taken, have those decisions been implemented, etc., etc. But that was the position in that particular. So again, the delegated powers within which government departments had to comply with conditions set by the state tender board had thresholds, had limits in terms of thresholds. The board would say, okay, we're delegating you, but not more than, as an example, 750,000. But those thresholds were set out quite clearly in the prescripts of the state tender board.
What I understand you to be saying is that there were much tighter controls, really, probably because the state tender board system was centralized and it was easier to then monitor and tighten controls over spending. Or would that not be a fair summation?
Look, Chair, I think in hindsight, when one looks back, the current, the existing framework is now in the system for more than 10 years. I think we introduced this in 2003. We are now in 2018, so we're talking 15 years at least of the current procurement framework. I'm sure one can always, in hindsight, say, yes, perhaps there was a reason to stay with the state tender board, but I cannot say convincingly that the board also did not have these elements, because there were also allegations against certain board members and their influence in terms of where procurement contracts should be going to. I think that's one of the reasons to say now, based on these, because these are board members, of course, and they live within communities, and they are not immune to, they were not immune at that time to some kind of influence, as is happening currently today. So, but at least there was some level of control at the time. Apart from the fact that the service delivery was very, very slow. And I think that's quite important. Service delivery was impacted negatively, quite negatively, and quite very, very slow in terms of the decisions of the board.
Yes, you do make that point. Maybe this is an appropriate time for you then to deal with the reforms, the revisions that you are considering as National Treasury. You'll find that section on page 33 of your statement, and you break it down in your statement. So if you could just help the Commission understand what measures you are taking to correct what you have identified as a project gone wrong. Those elements of the project that have gone wrong. I'm not writing off the whole system, just those elements that have gone off the rail.
Thank you, Chair, through you. Now, earlier on, we spoke about the complexity of the system, of the current framework, and we also spoke about the fragmented system, how fragmented the system is, where you have the core piece of legislation that are supposed to deal with procurement, but you also have a number of other pieces of legislation that have an impact on procurement. So in recognition of that problem, and also in recognition of the abuse of the system which exists currently, as the National Treasury, we are reforming the system. There is a bill, a public procurement bill, that would be a national overarching regulatory framework to deal with all these other pieces of legislation. So some of these pieces of legislation would be repealed through this bill, some would would be amended. There could be some amendments to make sure that you have one legislation in the country that deals with procurement. Whether you have people coming outside the country or in the country, but when you come to South Africa and you say, what is the procurement legislation in the country? We can then point out and say, this is a particular piece of legislation that deals with procurement process in the country. Now, the process is at an advanced stage, and of course, one of the issues that this bill will deal with will review the delegations of authority. Will also strengthen procurement planning, because I think that's where the problem is. There are also governance issues, because the failure of the system lies in governance, compliance, and so on. And we're also providing for the alternative dispute resolution mechanism. Chairperson, we don't want to always appear before courts to save costs. I'm sure we can have another system where we think it is. I mean, that's provided for in the bill. And then also the Treasury regulations themselves are in the process of being reviewed, and they will be published soon for comments. Because if you look at that chapter 16A that I've been always talking to, it recognizes your normal goods and services, but it does not address the procurement of infrastructure, and which is quite a huge spend in terms of procurement in the country. It does not address those processes, and it also does not address the procurement of capital projects, which you see currently you have power stations that are under construction in the country. I mean, that's capital. So that's what this particular piece of legislation seeks to do. And of course, to strengthen governance issues, as I indicated, and to make sure that it gives more powers to this office of the Chief Procurement Officer to play an oversight role and take action where there are infractions and abuse of this system. Currently, for instance, when accounting officers, for some reason, because they answerable to the ministers, so you can go that route and say, no, for me to deal with an accounting officer, at least you channel that through the minister, because that's a minister's responsibility in the current system. And I think it will remain as such for now. We don't want to make sure that there's a, but at least insofar as the transactions themselves, which are irregular in the process, we have much more powers to deal with those, take decisions, and where necessary, restrict people from doing business with government. So that's what is in this particular legislation. Also, the strengthening of contract management, because this is where, when we're talking contract variations, which is a very serious issue in this country. If you enter into a contract and the contract is 3 years, and all of a sudden the contract finds itself being extended up to 12 years or 10 years, it can't be. You can't allow that to happen. Because firstly, it creates the so-called evergreen contracts in the system. And it also serves as a barrier to entry by small, medium enterprises and also black-owned companies who find it very difficult to penetrate. And it also plays itself to the anti-competitive practices, collusive, cover coating, you can name them. And also the principle of value for money gets lost. And what is also most important is the risk that one takes to extend a contract. For instance, if if an application of to vary a contract is submitted, and you don't even know how this contract was procured in the first place, you're coming right at the end, you don't have all details of what happened, and then you extend this contract. Contracts get extended time after time, and this is also one area that I think we need to tighten very much to make sure that we improve contract management so that there's proper planning. When contracts are about to expire, government officials, those that are involved in procurement, embark on the procurement processes to make sure that we live up to the Constitution and to other pieces of legislation to make sure that there is transformation in the process. And it's an area that is also very much in our radar. The bill, of course, has to go through the normal legislative processes, and it will be published soon as well for public comments. I mean, this is what we've always been saying. And once Cabinet approves the publication thereof, we expect South Africans to submit comments. And it's quite urgent that we finalize this process. That's how urgent it is. And I think even at levels outside ourselves, there is an agency. Government is placed, this is part of its priority projects to make sure that the public procurement bill is out there, and then people can have an opportunity to comment and also to address all these other socio-economic objectives that we spoke to earlier on.
I understand what you're saying, but my next question is, how is Treasury going to build this capacity that you speak of? Because you speak to capacity in contract management, you speak to capacity in procurement planning, just by way of example. What practical steps or measures are you able to take to build this capacity?
Thank you, Chair. There is a process within Treasury currently to build capacity. There is again a division that's responsible for supply chain management capacity building. And of course, I think there are two streams there. The one stream is to professionalize this profession. Because currently, as I indicated earlier on, you can just take anybody and throw him there and say, go and procure. That's where the problems are coming. So to professionalize, to make sure that, and why professionalization? Professionalization to make sure that, like in any other profession, if Matebula is found to have flouted the processes, then the body that is responsible for that particular profession must take an action against Matebula and say Matebula must be struck off, just like in any other profession. So that's one part, to capacitate. But the other part, which is an agent part and practical for that matter, is really training and development. Because practitioners must be able to put together a tender document. That's what is lacking. Hence, we always appear before courts and so on, simply because the way our tender documents are crafted, you could clearly see that all these laws that we're speaking about, there is a lot of misinterpretation and so on. Hence, we land into the problem. So the immediate step that Treasury is taking is to make sure that we train people practically to put together a document that complies with the Constitution and all other applicable legislation. So that's one part. But the professionalization, we're talking to tertiary institutions, is much more long-term. And we also have a partnership with the National School of Government to make sure that we train people. We have also the forums that we always have, where we share information among ourselves as procurement practitioners in order to clarify policies, etc., etc. It might not be adequate, but it exists as we speak now.
As I conclude, can I ask you to apply your mind to the next few set of questions? The first is, you have told the Commission that the procurement spend of government is in the region of 800 billion. Is there a monitoring process to ensure that this money spent achieves its intended objective?
A difficult question, Chair. Quite difficult. But look, the whole process also talks to the public finance, the management of the budgets after the tabling of a budget by Minister of Finance in Parliament, that all of us, all divisions within the National Treasury are enjoined to make sure that government departments and public entities spend that money correctly. But of course, there is a challenge. There is a challenge because we can't claim that all this money goes to where it is directed to. Hence the problem that we're facing in the country.
Then my next question really is one that seeks to identify the real, where the problem really is located, these transgressions, the misspending of money. Is it the law that needs to change? Is it government policy that needs to be revised? Or do wrongdoers simply have to face the consequences of what they have done? Where do you locate, and I know you've spoken to us about reforms, where is the nub of this problem?
Chairperson, I think it's a combination of all this question. If you look at our regulatory framework as indicated earlier on, that for quite some time, some of our prescripts never applied to specific public entities, which we've now corrected, of course, through instructions. That's one. But also the bigger element is the human element in this process. Regulations are there. Hence, we augment them from time to time. But humans must also choose to make sure that there is compliance in the process. And of course, the issue around investigations and subjecting people to prosecutorial processes is well known, save for that maybe the processes at times take long in the current justice system. This is personal now. This personal, it's got nothing to do with the prescriptions. That perhaps we may need to look at whether we shouldn't reclassify procurement transgressions differently so that they get fast track, or even considering a special tribunal specifically to deal with these cases. Because otherwise, if you don't do so, then the road continues in the system.
Yes, in fact, this is also one of my last few questions. These criminal prosecutions, investigations that have taken place, maybe I should rephrase that. You have investigated certain matters and referred them for criminal prosecution. But once you've done that, you have no control over what happens to those transgressors. Is there anything that you are thinking through? Because really, you need to have a deterrent to malfeasance, an effective deterrent to malfeasance. Is there anything else other than these referrals to prosecution that you are knitting into your reforms, over and above the items you've already mapped out to the Commission?
Chairperson, I'm sure we can always take recommendations of what else could be done, but obviously we've always maintained a position that we need to send a shock in the system. And of course, the current instruments that we're using, where we bar people from doing business with government for quite some time. But of course, the other part is that the criminal part where people should be subjected to. But we are open to any proposals that we can include in our procurement processes for improvement.
Mr. Mathebula, are there any other material issues you would like to raise with the Commission within the context, of course, of public procurement?
Chair, except for saying that we will continue to serve and where we identify wrongdoing, that we make sure that the wrongdoing is dealt with. And of course, also to make sure that people who were historically disadvantaged by unfair discrimination do benefit from the procurement of this country. And I think we can say that without any fear that it has to be done, but of course within law. That's what we say. We need to advance them. Must be transformation, and people must repent at some point in time. I think this is where I will leave it for now, and thank the opportunity to appear before the Commission.
Not quite, Mr. Mathebula. But thank you very much. Chairman, there may be questions that you wish to put to Mr. Mathebula.
We are going to take, if you are done, the lunch break, because we are on my watch about 7 minutes before 1, and Mr. Mathebula must come back at 2 so that he can clarify certain things. You are done.
I am done, Chairman. Thank you very much.
Okay, thank you. Those who may have done something that has improved the situation in regard to my problem of hearing counsel, I think if they could do the same in regard to the witnesses' mic or speaker, it would be helpful. I can hear him, but if I can hear him as well as I hear counsel, that would be great. We'll adjourn then until 2 o'clock.
All rise.
Done. Thank you. Thank you for your inputs.